Artificial intelligence isn't just changing how businesses work, it's changing how the federal government works. The US Patent and Trademark Office is now using artificial intelligence at multiple stages of the trademark process, including technology that, according to the USPTO, has reduced certain application pre-processing from months to minutes. I'm George Sciarrino. I'm an intellectual property attorney, and for more than 12 years, I've worked with businesses and global brands on intellectual property protection matters, litigation, licensing, and commercial transactions.
This is Case and Effect.
But the real question isn't simply whether the government is using AI. It's where that efficiency comes from and how businesses and brand practitioners can adapt to these changes. That's where we'll start in this issue of Case and Effect. Then we'll look at several recent decisions involving trademark distinctiveness, trade secret timing, and copyright damages. And finally, we'll step back and look at something even more fundamental: how ideas, knowledge, creativity, and experience can develop into valuable intellectual property assets. So let's start with what's happening at the USPTO. The agency is expanding artificial intelligence across several stages of the federal trademark process. But we're not talking about one AI system replacing trademark examiners. Different tools are doing different things. The first is Scout LLM. Scout is an internal generative AI tool that supports research, analysis, drafting, and summarization for USPTO personnel, including examining attorneys. Examining attorneys still make the legal decisions. AI supports their work. The second tool is Class Act, the classification agentic codification tool. Class Act helps prepare newly filed trademark applications for examination and makes the underlying application data searchable much faster. Here's how. When a trademark application comes into the USPTO, the information has to be classified, coded, and organized before that application can efficiently move through the system. Class Act helps perform that work by assigning international classes and adding search and classification information, including design search codes and pseudo-mark data. That may sound administrative, but it's important to understanding where some of those efficiencies actually come from. I've spent years managing intellectual property portfolios involving thousands of registrations across numerous countries. And one thing that experience teaches is that different systems don't always use the same terminology, classifications, or data structures, or have the same integration capabilities. Getting information from different systems into a form that can actually be used can require a surprising amount of work. AI can perform some of that work extremely quickly. It can analyze large amounts of incoming information, identify patterns, and organize that information into a more consistent and searchable form. According to the USPTO, Class Act has processed approximately 250,000 trademark applications and reduced pre-processing that historically could take months to minutes. So that's part of where the efficiency comes from. The AI isn't making the ultimate legal determination. It's reducing some of the work that has to happen before that determination can efficiently be made. And that distinction carries into the USPTO's third AI development: image searching. Trademark attorneys can now upload an image and retrieve visually similar marks from the Federal Register. That's a significant search capability, but finding a visually similar mark and determining whether that mark creates a legal problem are two different things. The tool doesn't determine registrability, and it doesn't determine likelihood of confusion. Those remain legal questions for experienced intellectual property counsel. These tools don't just change how information is processed. They also change how quickly that information becomes available. Newly filed applications can become searchable earlier. That gives examining attorneys and trademark practitioners a more current picture of what's actually being filed. Better coding and better search tools can also surface potentially relevant records more efficiently. A recent trademark decision involving OpenAI serves as a useful example. OpenAI sought to register OpenAI as a European trademark for certain technology-related goods and services. The European Union Intellectual Property Office partially refused the application, finding the mark descriptive and lacking inherent distinctive character for certain goods and services. And in July of 2026, the European Union's General Court upheld that determination. The reasoning is easier to see when we look at the two terms separately. Open can mean available or accessible. AI is a commonly understood abbreviation for artificial intelligence. Putting two descriptive terms together and removing the space between them doesn't necessarily create a distinctive trademark. The combination still has to function as a mark, but there's another part of this decision that's particularly relevant to businesses operating internationally. OpenAI had registrations in other jurisdictions. Those registrations didn't bind the European Union Trademark Office. The European Union had to evaluate registrability independently under its own law. In an AI-driven economy, businesses can cross borders extraordinarily quickly. Trademark rights don't necessarily travel with them in the same way. A mark accepted in one jurisdiction may face a different analysis in another. Brand protection strategies, therefore, need to account for the possibility that different jurisdictions may reach different conclusions about the same mark. And even a finding of descriptiveness doesn't necessarily end the analysis. A mark can potentially acquire distinctiveness through use. OpenAI's recognition may be relevant to its separate claim of acquired distinctiveness, but establishing acquired distinctiveness after substantial marketplace investment is a very different position from beginning with an inherently distinctive mark. So there are two practical points here. Combining descriptive terms doesn't automatically create a distinctive trademark, and a registration or favorable result in one country doesn't guarantee the same result somewhere else. The next case involves a completely different area of intellectual property, but the issue is one businesses can encounter across many types of disputes: timing. Insulet versus EOFlow involved competing wearable insulin delivery devices and alleged trade secret misappropriation. A jury returned a verdict of approximately $452 million. The district court later reduced that amount to $59.4 million, and a divided federal court panel reversed the judgment. The reason was timing. Under the Defend Trade Secrets Act, a company generally has 3 years after it discovers or reasonably should have discovered the alleged misappropriation to bring its claim. Complete proof isn't necessarily required before that clock starts running. Here, former employees with access to Insulet's trade secrets had joined a direct competitor. The product appeared strikingly similar, and internal communications had already raised concerns about possible misuse. The court concluded that those warning signs provided enough information that the claim should have been pursued earlier. The practical issue then is what happens when warning signs first appear. Trade secret protection involves more than confidentiality agreements and cybersecurity. It also requires a process for recognizing warning signs, preserving evidence, investigating concerns, and documenting what is learned. When circumstances suggest that confidential information or trade secrets may have been misused, early consultation with counsel can help determine what measures should be taken to investigate and proactively mitigate the risk. Because the issue isn't whether a company had a potentially valuable claim, it's whether the company waited too long to bring it. The next case shifts from the timing of a claim to a different problem: how intellectual property is valued after infringement has already occurred. And this time, the defendant is the United States government. Sovereign immunity generally limits the circumstances in which claims can be brought against the federal government. But Congress has waived that immunity for certain copyright claims under Section 1498B that provides a statutory path for a copyright owner to seek compensation for copyrighted materials misused by the federal government without authorization. That's the framework involved in 4DD Holdings versus the United States. The dispute involved the government's unauthorized use of healthcare software and a copyright damages award of approximately $12.7 million. The parties already had licensing arrangements, but the government's use exceeded the authorized scope, so it became how much should the government have paid for that additional use. The Federal Circuit accepted a hypothetical negotiation as a way of approaching that question. Essentially, what would reasonable parties have agreed to pay at the time of the infringement? That sounds straightforward, but there's a complication. The court is answering that question years later. By then, information exists that the parties couldn't have known when the infringement began. Courts can consider some later evidence to help determine what the license was worth. That's sometimes described as the Book of Wisdom, but there are limits. The lower court had relied on part of the government's later abandonment of the project. The Federal Circuit concluded that went too far because an event that wasn't reasonably foreseeable can't simply be inserted backward into the hypothetical negotiation. So later information can help clarify value. It can't rewrite what the parties reasonably could have known at the time. And that brings the case back to something very practical. Proving infringement and proving damages aren't the same thing. Licensing agreements, pricing records, negotiation, implementation costs, and contemporaneous valuations can become extremely important when a court later has to determine what intellectual property was actually worth. Contemporaneous documentation can be much more useful than trying to restructure the same information years later. And that question of value leads into the final part of this issue. Some of the most valuable assets a business creates begin as things that can't be seen. Before intellectual property can be valued, licensed, or enforced, it has to be recognized as an asset. Before there's a company, an invention, a book, a brand, or a piece of software, there's usually an idea. Maybe it's an observation, a problem that needs to be solved, a creative concept, or simply the realization that something could be done differently. An idea becomes a company name. Knowledge becomes a proprietary process. Creativity becomes original content. A solution becomes software. Experience becomes expertise. And through execution, something that began entirely in someone's mind can start creating real business value. This happens constantly. A founder identifies an opportunity. A designer creates a brand identity. A developer writes software. An author creates a manuscript. An inventor develops a solution to a problem. But not every valuable, intangible asset automatically becomes protected intellectual property. Sometimes businesses simply don't recognize what they've created. Sometimes it isn't documented. Sometimes ownership isn't clear. And sometimes the asset becomes valuable before anyone asks who actually owns it or how it should have been protected. That's why identifying intangible assets early can matter so much. And it raises a practical question. How does something intangible develop into an asset that can actually be protected and commercialized? We've developed a framework for thinking about that process through 4 connected stages: strategy, creation, identification, and ownership. Strategy establishes direction. What is the business trying to create? What problem is it solving? How will it distinguish itself? And where could the resulting asset create value? From there comes creation. Creation gives the idea form. This might be a brand, an invention, software, a design, a proprietary process, a creative work, or a marketing campaign. Once something has been created, the next step is identifying what the business actually has. What was created? Who created it? Who owns it? What rights may exist? And how does the asset fit into the business? That step sounds simple, but it's often where problems begin. A business can't strategically protect an asset it hasn't properly identified. And that leads to ownership. Ownership establishes the legal foundation for what comes next. That can include protection, licensing, enforcement, investment, and other commercial strategies. The point isn't that every idea automatically becomes intellectual property. It doesn't. Businesses do, however, create intangible assets constantly. The opportunity lies in recognizing which of those assets matter, establishing ownership, and aligning legal protection with the commercial objective. Ideas create potential. Ownership creates value. Technology is changing. The institutions that administer intellectual property rights are changing with it, and businesses are creating valuable, intangible assets faster than ever before. The opportunity isn't simply having more information. It's recognizing what matters and knowing what to do with it. I'm George Sherino. This is Case in Effect.